Ladies and gentlemen, before getting started with my presentation, I would like to thank to the organizers for inviting me and for giving me the possibility to present the way how our institution communicates on its rulings. Basically, the exact title of my presentation is Harmonizing Clarity and Accuracy in the Communication of the Court of Justice. These two major things, so clarity and accuracy, are those about which we were talking also in the context of the former presentations. So how we can speak to our target audiences in a clear, but at the same time, and in the same time in an accurate way, which is also suitable not only for the general public but also for lawyers. If we have a look at the group of persons to whom we address our communication, we can strike a clear distinction between two major groups. The first being journalists, or the general public to which journalists transfer information. And the second group is the group of legal professionals. Each of these groups are, of course, composed of different subgroups, so we are not talking about homogeneous groups. Especially referring to journalists, it's worth, we should, I think, know who the term journalist covers, because this is far from being a homogeneous group of people, and their needs can also be different depending on in which activity they are precisely engaged. But we will see it here. So here I just highlighted the general needs of journalists, but when it comes to communicating the judgments of the Court of Justice, we have to split these judgments into different groups. We have judgments which are somehow linked to our traditional rule of being a court for commercial, trade, and economic cases, which was the case 30 years ago, and which has not anymore the case, because in the meantime we have also become a court of much more publicly followed issues such as politics, migration, or the financial crisis, for example, in the European Union. So whilst we see that journalists, generally speaking, need quick, concise, legible information, we should also distinguish between journalists, because there are journalists who work really with time and on time, and they need the information immediately. And not only they need the information immediately, they have a good reason to have this information immediately, because they are integrated into the data transferring mechanism of financial markets. So there is a court judgments, and we have a lot of judgments which directly relate to the functioning of financial markets, so that the markets can take into consideration appropriately what the court is decided there should be, and immediately after the decision has been given, there should be an information from a journalist, because it's a journalist who is a primary source of this information, who gets this information and who transmits this information towards the financial markets. So we have journalists who are specialized in this. These journalists need information immediately and in a very simple way and in a very structured way, so they can immediately forward it in the minute in which the decision has been published. Then these same journalists or other journalists need 5 minutes or 10 minutes, so they can create a first and a more detailed analysis of the judgment. And then will come the other traditional journalists that we know very well and whose articles we read every day in newspapers, who work on the issue half an hour on an hour, and then there will be a relatively lengthy article on the judgment. But at this moment, when our journalists, which are the journalists in the general sense of the word, issue their work on the major newspapers, the impacts of the judgment have already come into life and have already been noticed and used by the actors of the financial markets. So it's just, I just mentioned this because we have, I would say, 5% of our cases which are so-called market mover cases and which have a direct impact on how markets function and will move towards one or the other direction. But now back to the general topic. Journalists not only need information on the decision, but they want also know where the decision comes from, which are the legal and the factual background of the decision, and what the impacts of the decision are. I will come back to this point later in my presentation, whether we can say to journalists information which is not stated in the judgment, whether we should do this, and whether we do this actually at the court. And the third is, when speaking to a journalist or communicating information towards journalists, the important thing for them is to have the information immediately and in an understandable way and understandable form. Minor inaccuracies in the information doesn't constitute a problem for them. So if they can grasp the essence of the message, on the basis of simplified information, they will be happy with it. On the other hand, we also have to live up to the needs of legal professionals, because besides journalists, they also read our communication materials, and they also need the information that we put at their disposal. Contrary to journalists, they have the tendency to need a legally solid summary of the ruling, which is also in which they can also find references to sections in the judgment from where we took out information in order to draft the press release. For legal professionals, inaccuracies are not acceptable, which means, and somebody already before me told about it, I'm convinced that the majority of the lawyers who needs to be informed about our court's judgment, won't go to directly read the judgments themselves, but will limit themselves to reading through the press release, and on the basis of the press release, they already want to have a general overview of what the court in that specific case has decided, and they need all relevant information from the judgment on the basis of the press release that we provided them with. So these are the main differences between the two target audiences, journalists and lawyers. Now, what is one of the major tasks of our group as a press team at the Court of Justice? We have to take into consideration both needs. So the needs of journalists and also those of lawyers, and we have to produce a product which lives up to the expectation of both of these groups. The major tool that we use with a view to explaining and communicating our decisions is the press release. The press release, later on I will show you some example of it so you can have a better understanding of how it looks like. It's an unofficial document, so it's still not an official document of the court. By the way, the judgment that you find on our website, it's not an official version of the ruling either. The official version is only the one which was as such published in the so-called recueil, so the, I don't know the English term, where we put all the judgments from our case law. And this is also on our website since for a year, I would say. Beforehand, there was only a paper version of it, and this is only the original and official version of the judgment. What we have on the website, it's not the official version, and the communique or the press release we issue, it's not an official document of the court. So, in case there is an allegation from a lawyer that an information is not accurate enough compared to the judgment, we can rectify the error if we recognize that that was actually a mistake from our part. But it can be never stated before any authorities or courts that I have this and this damage arising from a press release of the Court of Justice. However, the press release, the major feature of the press release and the major difference in having a press release compared to our other communication products is that this document is systematically and timely, so within a short period of time after the judgment having been pronounced. We publish it on our website, so anybody can have an access to it. Before publishing it, we can already send it to journalists and to lawyers who happen to be included in our mailing lists. Anybody can be there. There is no limitation thereon. And as I said, the main objective of this is satisfying needs of both journalists and lawyers. And now I would like to highlight how we incorporate into the process of preparing a press release this dispute or this controversial relationship between clarity and accuracy, which elements of the drafting procedure contribute to having a press release which is apt for being used by journalists, and which filter mechanisms in the procedure helps us remain also legally solid in the judgment, so in the press release, so it can also be used without problems by lawyers. When we start drafting a press release, we have an internal, vademecum, an internal code of drafting press releases, in which you find some basic information addressed to those who draft these press releases. And from this information, you will already know which are the criteria that should be met by the author of a press release. So as also the presenters before me mentioned for judgments, this also applies to press releases. We should avoid using unnecessary legal terminology. We should translate the ruling into a layman's language. We should be as concise as possible and do not use lengthy sentences. These are evidences. I don't add any new comments on them. Where I will have comments, I will comment them on the spot. Simplify your language. Somebody taught here, avoid using passive sentences, use verbs rather than nouns in the sentences. So there are small tricks which already of which we already make use when we start drafting the press release. Now a bit about the style. The heading, from a journalistic point of view, has a key issue, because, as I said, the press release is sent to different groups of journalists too, and the first group of journalists that I just mentioned, they need the information already from the heading. So the first reaction of a journalist on a press release will be drafted or will be perceived on the basis of what they find in the heading, in the title of the press release. So your story, you should, in some way, as a press officer, as you want to present the judgment to the general public, you should address them your product in a form which can be consumed by the general public. So it's not enough to take out fragments of the judgment and just put into the press release one after the other. Even if you know which are the most important parts of the judgments, it's not enough to copy-paste them and to have them together and call it as a press release. It will be a press release, but its informative value and informative force will be compromised by the fact that you didn't take into consideration the needs of your public. So that's why the heading in itself, according to my opinion, and we not always manage to have have a good heading in our press releases, but at least we have to make efforts in order that the heading inform the general public and journalists and lawyers of the essence and the most important part of the decision. Then I would refer to the point 3, be dynamic, tell a story with only a limited number of references to legal background. What do I mean by telling this? First, it's good to have a story. So if it's a VAT case, so value-added tax, there needs to be a company there. If it's a well-known company, it's even better, because it will grasp the attention of journalists. But if you just find a person who is known in the target country, or somebody in the judgment that you could use in order to draw the attention of your readers to your content, you should use this. There should be also figures therein. So if the company was fined by the tax authorities with a huge amount of penalty, that should also be there, because journalists are interested in how much a company had to pay for having committed something, a breach against tax rules. But this applies not only to taxation, this applies to each area of law. So if you have such attractive elements, this helps you already to power up your content and to attract your journalists to your content in order that they read it. Then you have to have a story. There might be different stories within the story. There might be appeal procedures between the national procedures. There might be appeal procedures between national courts. Nobody is interested what the first instance administrative authority decided. Nobody is interested either what the second instance administrative authority decided, except for the sum, the penalty or the fine that it imposed on a company, for example. Nobody is interested what the first instance court decided. If we having a preliminary ruling case from a second instance court, all we need to put there is what was the problem between the company and the national administration without referring to which national administration, it was the first instance or the second instance. And then that the case landed before the national courts, it's not interesting either to the public to which national courts, that it was the local court of this and this town and they decided and they had this and this view of the problem. What they are interested in is knowing what the court that addressed the question to our court wants to know from us, and in order to give that court a good answer, what is necessary to be told from the questions that that national court addressed to our court. So we should limit the story on the pertinent, on the relevant part of the background history, actually. There can be also, before the national court, different issues. There can be the story of the fine that the company was fined, but also there can be questions whether the first instance national court can do this in the internal legal system or not. Or there can be also questions on whether, under which conditions a national court should refer a question before the EU court, etc. These are interesting issues for lawyers and also for national judges who will be dealing with such cases. But these are not only points or elements of no interest to the general public, but they would distract the attention from the national public from the main issue, and they would get just lost amongst the information we put in our message. So that's why, if I have, for example, a taxation case, I will focus on the fine, how it went through which company, the national tax authority, how it landed before the national court, what the problem is before the national court. If there is one major problem, I will be focusing only the one major problem. There can be also problems of secondary or less importance. If they are not necessary, I will not mention them. Those who need information on that can then speak about it or can later read through the judgment itself. And then, so we identify the problem, we need to find a solution. So when we give out a press release, there should be a message what the court intends to communicate to the general public. That should be therein. I don't claim that it's possible in every case to convey a message to the general public, but at least we should make a try. So, in order to reach this, we have a first filter after the press release having been drafted, a so-called linguistic control. We work in French at the Court of Justice, and the other presenters already said what the problem with French language is at the court. We have a French language correction integrated into the approval mechanism of the press release. They ensure the respect of the drafting rules, eliminate grammatical and orthographic errors, and improve the style whenever it's necessary. So it's a first filter after the drafting by the author of the press release. Then there is a journalistic control made by Juan Carlos, the head of unit of the press and information section, who is the only true journalist in the team. The other members of the unit are lawyers. So it's his duty to ensure that the text is ready for publishing as a piece of news. He checks the adequacy of headings, eliminates redundant parts from text and the unnecessary legal terminology from text. So this is the second layer or filtering element in the preparation procedure. Then, on the other hand, we have also a filtering in order that the press release remain accurate enough for lawyers as well. So there is, within the framework of our unit, we are still within the framework of our unit. So the linguistic control, the control by a journalist and a lawyer who used to be working in a cabinet of a judge. She will have a look at the press release, compare it with the judgment, make sure that all information in press release comes from the judgment. It's important just in extreme cases or in urgent and important need of communication. We insert information into the press release which we cannot derive from the judgment directly. She is in charge of detecting inaccuracies in the text and weighing the content from a legal point of view, which information should be there and which should not be there for lawyers, or legally which are those which should absolutely be there and which should be omitted and which should be removed from the text. After the internal control, this was the internal control, there is also an external control which is carried out by the judges and by the cabinets of the judges. The judges verify if the text actually conveys the message they want to send by their decision. The judges draw the press unit's attention to ambiguous parts in text, because there can be, or there might have been, a reason why a judgment is not understandable, because that might have been a compromise reached by the judges who drafted it and who were not able to reach a better version or a better wording of the text, but the compromise reflects exactly what they agreed on and to what we should also stick our communication. Then, of course, they correct inaccuracies, remove unnecessary, and add the missing information. However, and this is the major problem of the preparing of the press release, the judge's intervention might result in the text partly losing its communicative value. What does it mean? That judges may take out information what should be in text according to communicators, or they add information that should not be there. And they do it not only in the main text, but they do also it in the title, in the headings. I will show you an example immediately. Then they put lengthy sentences and they use in an excessive way legal terminology, useless references to legal acts, and they also make amendments in some parts of the text, so the text will not remain coherent enough, because one part they didn't touch, one part they touched, and the coherency is lost. If we just have a look at a former judgment, you can see what there is a problem. I will need the time we are losing.
Ez nem csinálja? Lehet, hogy kell. Csak.
Well, that would be nice for you to see this. I don't know whether we can find a solution. Okay, when they come back, I will continue the presentation, and so I will show this as soon as I will have access to that part. Now, the solution is coming, maybe.
Miért van időben? Ez volt az?
Na, ez volt, nem a webről egy PDF.
Melyik volt az? De ez?
Ez meg a többi kettő, ami ott van, majd utána ki kell rakni.
Jó, ez igazságot néz. Így jó vagy?
Hát, mert ez csak egy része, maga a PDF, ez a rész, hogy ezt ki lehet vetíteni.
Kivetíteni? Ez most csak az egyiket, nem, ez nem ugyanaz, ez csak az egyiket hozta ki, mert ebben az a csávó.
Yeah. here we are.
Mindegyiket vissza kell húzni, vagy csak ezt?
Mindegyiket majd.
Nem tudom, mi történt az ajzával.
Elvittük oda?
Most túl oldalt vannak. És itt vannak ezek.
Kiterjeszted be az új.
De miért nem csinált ezzel?
Ha fogod, érted?
De tudom, mit mondasz.
Azt vett, hogy ugyanazt vetítsek ki, hogy ez a másolás.
De mi a francol történt ez a szar?
Magával a program húzzon magával.
Nem is értem, miért csináltam.
Mindjárt meg lesz.
Ja.
Most ugyanaz van a...
Igen, jó. Itt vannak lent ezek.
Okay. Okay, so now we have it here. And if you just have a look at the title and the subtitle, this is a version after having been read by judges. The first title is they left it untouched, the original version, and the second they made some slight modifications in the subheading. If you just have a look at the subheading, it's absolutely unacceptable for me in a press release. And however, this was the version that we published on our website and we sent out to journalists in a quite important case regarding data protection. It has 1, 2, 3, 6 or 7 lines. Even in a judgment, I would say that is not sufficiently well drafted. So it was just to illustrate, and now I hope I can go back to my presentation. Yeah, I'm there. So I still need 5 minutes. Okay, just I have to jump. Okay, what I wanted to tell you as judges, when we speak about simplifying questions, and also there was a question here in the debate after the former presentations, how we can give out a concise version or a concise and understandable judgment on a request or an application which has more than 200 pages. This problem we face also at the press division, but we have a very good teacher, or we have very good teachers at the court, the judges themselves. Those who are familiar in sending cases to Luxembourg for a preliminary ruling, they know that if they ask 20 questions of the Court of Justice, it's very possible that there will be only one answer to those questions. So there will not be 20 different answers. So even if you are very detailed and precise in the way you ask questions of our court, the court itself will simplify your questions and will say that in essence, so in substance, the national court wants to know, and then. And this is the way how systematically the court works on the basis of questions as of national judges. So it's very easy for us to work in the same way, where we have to communicate a case in which we have 20 questions from a national judge. I just pick the one that the question that the court reformulated and considers now as the one that should be answered, or I just take if the court still have many or more questions, I can take the 2 more interesting ones, and I will be focusing on them in my press release. And if the judges consider other parts of the judgments as necessary to be integrated into the press release, they can subsequently add it to the press release. We can also play with the judgment. We can build up our story, not in the way in which we want to present it to the general public. We are not bound by the order in which information in the judgment appears. We can take out segments or parts. We can start speaking about the first parts, then the ending part of the judgment, and we can make an understandable text on the basis of the whole judgment, the judgment as a whole. And also, the important factor, we always speak about the judgment. If it's an appeal judgment from the general court, we don't speak too much about what the general court said. If there was an opinion of an advocate general, we'd never speak about the opinion of the advocate general in the court's judgment, or in the court's press release on a judgment. And we also put information within the press release that helps the general public and journalists understand the main features of the procedure before us. So if it's a reference for a preliminary ruling, we don't have an explanation in the text, but at the end of the text there is an explanation what is a reference for a preliminary ruling, so they can know the procedural context of the case. Also, we provide them with information whether the case can be appealed or not. What is the role of the Advocate General if we communicate on an Advocate General's decision? And also the question is, and at the end of my presentation I will, in one more PDF document, is whether we can give information on the impacts of the judgment in the judgments if we can, to some extent, interpret or explain, not interpret, but explain to journalists what implications the judgment might have on the member states or the general public in the member states. And this is the very last slide I want to present to you. When we are facing very complicated and complex issues, we can also send the press release with an attachment with another explanatory document which give either explanations on specific procedures, if it was an expedited procedure, what is an expedited procedure, if there are, this is a sanctions procedure against a member state, what is this procedure? And on different areas of case law, for example, if we have a well-established case law in the protection of airline passengers or borrowers of credit, we also put in a different information paper some background information for journalists next to the press release. And now I will, to finish my presentation, I will just jump back to the two PDFs. I have it, yeah.
Nem tudom, ez miért úrik el. Jó, most nem vettem el. Most ugyanazt látom.
Most jó? Here, it's just to illustrate, and also we talked about this already, there can be also controversial and important information in the same text. For example, we had a case regarding the sanctions, EU sanctions imposed on former Ukrainian President Viktor Yanukovych. The sanctions list concern a limited amount of time, it's always 1 year. In respect of 1 year, the sanctions were annulled by the court, and in respect of years which are still in progress, which are the current calendar year, the sanctions were upheld. So we had to decide on which part of this controversial information to focus. So of course, as the sanctions in substance remained in force, we put in the title that they are enforced, and then only in subtitle and the text we explained that for a year the sanctions were not adequately imposed on Mr. Yanukovych, so for that year that sanction was annulled, but as of now the sanction which then subsequently was imposed on him is still in force. That's one thing. And the last thing, if I found it here in the open documents, it's the end of the same press release I've already showed to you. Here, exceptionally, we got the right from the judges to add information on the impacts of the judgment into the text. So we try to negotiate with them, so we can explain to the general public what will happen now in the light of the court's decision. Because we had the ruling, but it didn't resolve the case, and we were in need of explaining this also to the general public. And in this sense, just to close my presentation, a very recent example and a very good example which was linked to a Hungarian case or a Romanian case, but which concerns also Hungary in the subject of loans which were granted to consumers in foreign currencies. I think that we should have done also the same thing, because the journalists didn't really get the message of our press release. I was looking for articles. We do also the press review of our communication. I found only 2 or 3 articles, and I didn't find really understand what now the Hungarian and Romanian courts have to do, and what the outcome possibly of these proceedings can be, that in extreme cases there can be scenarios where these terms of these loan contracts which oblige the consumers to exclusively bear the risk of the fluctuations in currency rates, these might be considered under certain circumstances by the national judges as unfair and as not binding on the consumers. But there is a logical chain that was not provided to journalists, and they didn't grasp the stakes of the case. So I think in next similar cases, we will be obliged either to put such an explanation at the end of the communication, or to provide journalists with a separate document in which we explain to them how this system exactly works, what's the rule of the Court of Justice, what's the rule of the National Court, and what might be the outcome of the procedures also before the National Court in the light of the judgment of the Court of Justice. And now that's the moment where I say thank to you for your attention and for your patience because of having a bit spoken more than I should have. Thank you.